to show why it is wrong. Judge Connor says defendants contend that the applicable state and federal regulations require them to provide at least one public access channel per franchise area. Defendants contend that the contemplated restructuring of public access programming will meet the standard because each franchise area, each municipality will continue to provide at least one public access channel. Plaintiff was not able to provide the court with a convincing argument to the contrary. Well, plaintiff didn't get a chance, and this is not so. You just read Glendora's convincing arguments. There is no convincing a biased judge. Judge Stewart and Ardsley did better by Glendora in 1983. Glendora versus Franklin Chemical. Judge Connor's pages are not numbered, and Glendora hates that. This is page 60. Ron Pure, a producer, spoke, and it bombed because Judge Connor could not hear. Judge Connor let him speak as friend of the court, amicus curiae. Glendora did not get a chance to ask Judge Connor for two applications, start discovery and home addresses by Local Rule 2. A party shall furnish to any other party within 5 days of demand a verified statement setting forth said party's post office address and residence. And if a corporation, the name, post office addresses, and residence of its principal officers. Cablevision failed to do that. Continental has failed to do that. And TCI, I want to make an application that TCI does that and follows the law for a change. Judge Connor writes, furthermore, we have some doubts as to whether plaintiff has demonstrated a likelihood of irreparable harm if we do not grant the request relief. First of all, who is we? He's one judge. He's not a three-judge court. On the bench was Judge Connor and Judge Connor alone. Glendora without doubt demonstrated irreparable harm. She could have demonstrated more if Judge Connor had not wasted all that time listening to the monologue of Mr. Koenig. Judge Connor writes, while irreparable harm usually results when the First Amendment is violated, we are not persuaded that plaintiff's First Amendment rights are implicated in this case. Okay. Who took my speech, acting under color of state? Who took it away? TCI. And that's not First Amendment? Acting under color of state, if Glendora's programs are not cablecast on Channel 8 where they have been for 8 years, and if the municipalities are not able to cablecast her programs, then why hasn't her freedom of speech First Amendment been violated? We should be persuaded. Judge Connor is dead wrong when he writes she is not alleging that she is being prevented from speaking or even that she is being prevented from speaking on public access television. How can anyone read her complaint and make a statement like that? Judge Connor writes, instead she asserts that the restructured public access programming will impose substantial new burdens on her in distributing her program to the same audience that she now enjoys. Glendora rebuts, she is claiming both. Judge Connor, we do not doubt that her show will be less visible if it is broadcast at different times and on different channels in the various municipalities. Doesn't that admit restraint of freedom of speech? We do not doubt that her show will be less visible if it is broadcast at different times and on different channels in the various municipalities. Quote, less visible, unquote, equates to being prevented from speaking, quote, unquote, to the people she has spoken to for 8 years on Channel 8. That's you. And let Glendora point out to you that there is a big difference being on Channel 8 between highly viewed Channel 7 WABC TV and highly viewed Channel 9 WWOR TV and being on Channel 14, 15, or 16. Writes Judge Connor, at this time, however, there is no way to predict how great the burden some plaintiff may be or to estimate the changes in the distribution of her program that may occur. Ergo, we need, indispensably, a temporary restraining order and preliminary injunction so this judge can figure this out. The judge doesn't have the information required to make a decision. Judge Connor, in the absence of such evidence and in view of the fact that defendants have represented that they will, within the framework of the requirements of the applicable federal and state laws, use all reasonable efforts to facilitate the distribution of plaintiff's program. They don't, it's not a case of using all efforts, it's a case of doing it. It's the law. And what do we have in writing that they will? Glendora tells the Second Circuit that she just talked to the manager of White Plains Public Access, and he says everything Mr. Koenig was telling Judge Connor is technically wrong. Yes, that he is wrong. And Mr. Strauss says this after being in public access and on TCI systems since 1982. So the judge got wrong information and based his order on wrong information and is therefore wrong. He is wrong about not granting a temporary restraining order, so please this court vacate his decision and grant a temporary restraining order and preliminary injunction. Glendora said to Mr. Strauss, and why didn't Judge Connor grant a temporary restraining order and PI? Mr. Strauss, he's afraid of him. Now, Mr. Strauss was there during the whole hearing. He should have been called upon. Glendora told Judge Connor he was there. Further, Judge Connor should have heard from Mr. Figliosi and Mr. Shea, which is the regulatory body of the state of New York, and they would have told him how wrong Mr. Koenig was. Further, Mr. Strauss, and this afternoon while Glendora was editing her program at White Plains Public Access, operated by the city, that he frankly does not believe that TCI lacks channel capacity to carry WRNN and Channel 8 public access and has ordered a technical audit of TCI to see if they are telling the truth. Figliosi and Shea came all the way from Albany Monday night to be at the Judge Connor hearing Tuesday, January 23rd, 96 at 9 a.m. If a temporary restraining order is not needed for time to hear the truth from the regulatory body by a judge who has not heard the truth from Mr.